Today is Wednesday, April 1st, 2026. For hundreds of thousands of green card families, this is not just another day on the calendar. It is the most significant tactical opening in the U.S. immigration system we have seen in over 5 years. As of this morning, the dates for filing chart for the F2A category, spouses and children of permanent residents, has officially jumped to current across all chargeability areas. This is a massive high-stakes opening in the processing fog that allows you to file your I-485 adjustment of status today, regardless of your priority date. But there is a hidden danger buried in this good news. While the window is open today, my technical analysis of the 2026 surplus math shows that this door is already beginning to creak shut. Between the ongoing DHS shutdown, now on day 46, and the sudden shifts in consular processing data caused by the Mullin-era enforcement spikes, we are looking at a high risk of retrogression by midsummer. Today, I am giving you the exact strategic roadmap to lock in your work authorization and travel parole before the government realizes its mistake and slams the gate. If you wait for the May Bulletin, you are gambling with your family's future. We are moving past the headlines and into the actual math that protects your status. Welcome to U.S. Immigration News Daily. We deliver verified, actionable updates on USCIS and visa policy every Monday, Wednesday, and Friday at 2 p.m. Eastern. No rumors, no jargon, just the facts to protect your status. Let's get straight to the facts. This information is for educational and news purposes only. It does not constitute legal advice and does not create an attorney-client relationship. Immigration policy in 2026 is extremely volatile due to the DHS funding lapse and the total shift to AI-driven intake systems. Always consult with a licensed professional regarding the specific technicalities of your I-485 filing package before you mail it. Part 1. The April 1st Current Miracle Explained. Let's break down the technical reality of the April 2026 Visa Bulletin. Last month, the F2A dates for filing chart was lagging behind. Today, it has skipped forward completely to current. This means the Department of State believes there are enough visas available to allow every eligible family member currently inside the U.S. to start the paperwork process. If you are the spouse or unmarried child under 21 of a green card holder, and you are physically present in the United States on a valid non-immigrant visa, you are eligible to submit your I-485 packet today. Why is Chart B, the dates for filing, the focus of this authority builder? Because USCIS has officially confirmed that for April 2026, they are honoring this chart for adjustments. In 2026, Chart B is where the real victories happen. Most consultants only look at Chart A, the final action dates, which tell you when the green card is actually issued. But Chart B is what gives you legal tolling. Filing under Chart B today immediately triggers your eligibility for Form I-765 for work authorization and Form I-131 for Advance Parole. In a 2026 economy plagued by the shutdown, these documents are your primary insurance policy against deportation and job loss. Part 2. The surplus math logic. The 2026 consular freeze. You have to ask yourself, why did the government move the date so fast during a day 46 shutdown? The answer is technical, and almost no one is talking about it. It's tied to Presidential Proclamations 10,949 and 10,998. These orders, which froze immigrant visa processing for high-risk nationalities earlier this year, have created a massive visa surplus at the State Department. Because consular offices abroad are not issuing visas at their normal rate due to staff furloughs and security vetting pauses, those unused numbers are being dumped back into the domestic pool for people already here in the U.S. But here is the danger. This surplus is artificial. As of this morning, USCIS is managing a record backlog of over 11 million pending cases. The only reason F2A is current today is that the consular pipeline is clogged. My data tracking shows that the State Department is preparing to release updated issuance statistics in late May. Once the AI systems recalibrate those numbers, the visa surplus will evaporate. Retrogression, the movement of dates backward, is not just a possibility, it is a mathematical certainty for the summer of 2026. You are currently standing in a temporary gap in the system that will not last. Part 3. DHS Shutdown. Day 46. The Processing Fog Tactics. We are now on day 46 of the longest DHS shutdown in history. While USCIS remains open because it is fee-funded, the interagency coordination is failing. Specifically, the Department of Labor furlough means that prevailing wage determinations are stalling for employment cases. This has created a unique vacuum where family-based cases like the F2A are actually moving faster through the mailroom than employment-based cases for the first time in years. This is your first mover advantage. The total pending I-485 inventory currently sits at approximately 720,000 cases. If you wait even 2 weeks to file, you are essentially placing yourself behind the 100,000 new applicants who are filing today. In major field offices like Chicago, New York, and Los Angeles, this April surge will push total processing timelines past 26 months. The window isn't just about the date on the calendar, it's about your place in the queue before the AI intake system breaks under the weight of this new volume. Part 4. The Strategic Rebuttal. Why you cannot wait. I want to address a dangerous consultant trap. Many attorneys are telling their clients, "The date is current, take your time, gather your documents over the next few weeks." This is catastrophic advice in 2026. Here is the strategic reality. Retrogression risk for the third and fourth quarters of the 2026 fiscal year is now above 85%. If you wait until May or June and the State Department moves the date back to 2024 or 2025, your application will be pended indefinitely. You will lose your ability to get a work permit. You will lose your ability to travel. By filing this week, you lock in your benefits under the 2026 filing rules. You are filing to secure your receipt notice, which protects your status even if the Bulletin moves backward next month. If you are current on the day you file and the check is cashed, you are protected. If you wait, you are gambling with a door that is already closing. Part 5. The April 1st Filing Compliance Audit, form by form. If you are an F2A applicant, here is your 48-hour checklist. In the Mullin era, the AI intake malfunctions are currently rejecting 12% of packets for simple clerical errors. A rejection right now means you miss the window entirely. Medical exams, I-693. In 2026, you should file your medicals concurrently. Do not wait for an RFE. The backlog for RFE processing is currently 8 months. Submit the sealed envelope with the initial packet. The 2026 fee schedule. Ensure you are using the exact fee points effective today. The shutdown has caused confusion, but lockbox staff are strictly rejecting packets with outdated checks. $1 off means a total rejection. Digital signature quality. The 2026 digitized intake system is rejecting faded or low-resolution scans. Use original blue ink for your signatures to ensure high-contrast scanning in the automated machines. The priority date lock. Attach your I-130 approval notice to the very top of your I-485 packet. Make it impossible for the AI to miss it. Part 6. Navigating the Day 46 Lockbox Logistics. The processing fog of Day 46 means that mailroom staff at the USCIS lockboxes are working with skeleton crews. Do not use standard USPS mail. I am seeing 15-day delays just for delivery to the facility. Use a private courier like FedEx or UPS with signature-required tracking. If your packet is delivered but not receipted before a retrogression event, you could be in legal limbo. Your goal is to have a digital receipt notification in your inbox before the April 15th tax surge hits the same processing centers. Speed is your only defense against the backlog. Part 7. The Notice to Appear risk for out-of-status families. This is a critical warning for those whose non-immigrant status has already expired. Filing an I-485 based on Chart B when you are out of status is an extremely high-risk move in 2026. Under the new Mullin enforcement priorities, if your adjustment is rejected for a technical error, like a missing signature or an old fee, and you have no underlying status, you are an immediate target for a Notice to Appear in immigration court. This is why you must have a professional audit of your packet before it leaves your hands. The stakes in April 2026 are not just delay, they are deportation. Part 8. The Phantom RFE, warning for April filers. Finally, be prepared for the Phantom RFE. Because the AI intake system is struggling with reduced server capacity during the shutdown, many April filers will receive automated notices claiming documents, like birth certificates or tax transcripts, are missing when they were actually in the box. If this happens to you, do not just resubmit. You must include a formal legal rebuttal identifying the digitization failure of the 2026 system. If you just send the papers again, the AI flags it as redundant and can trigger a denial. I will be covering this rebuttal framework in depth in my strategic case reviews this month. Part 9. Post-filing surveillance, what to watch for. Once your packet is in the system, you must remain vigilant. In 2026, USCIS has deployed real-time biometric monitoring. If you have a change in employment or residence within 90 days of filing this April surge packet, You must update the system within 48 hours. The previous 10-day rule is being ignored in high-volume field offices. Failure to update the system during the processing fog is being cited as a failure to maintain status. This is the level of detail required to win in the current climate. Today, April 1st, is a day of hope for F2A families, but it is also a day of extreme tactical urgency. The window is open, but the processing fog is rolling in. Do not let this artificial surplus go to waste. You have the facts, you have the math. Now, you must act before the government realizes the surplus is gone. If you are confused by the surplus math or worried that your priority date won't hold through the summer, do not gamble with your family's future. Click the link in the description to book a strategic case review now. We will audit your filing timeline and ensure your packet is retrogression-proof before the window slams shut. Staying informed right now is not optional, it is essential. Subscribe to U.S. Immigration News Daily. Hit the bell. Every Monday, Wednesday, and Friday at 2 p.m. Eastern, verified updates, no noise, no spin. Share this video with anyone managing an active immigration case. They need to see this. Stay informed, stay prepared, stay protected, and I'll see you in the next update.